I have heard Mr. Dhaval Vakil, learned advocate appearing for the petitioner, and Miss Moksha Thakkar, learned APP, appearing for the respondent number 1, State of Gujarat. Mr. Vakil has mainly submitted that the statutory notice dated 4th August 2021 is not duly served upon the present petitioner, and thus, in absence of the service of statutory notice, the impugned complaint under section 138 of the Negotiable Instrument Act is not maintainable. He submitted that apparently the endorsement of the Postal Department on the cover of statutory notice, it seems the address of the present petitioner as narrated is Keyur Kumar Prabhudas Patel, A 12, Saundarya Apartment near Ghatlodia Police Station, Ghatlodia, Ahmedabad, whereas the present petitioner is residing at E 12, Saundarya Apartment near CP Nagar, Ghatlodia, Ahmedabad. In that view of the matter, according to Mr. Vakil, it cannot be said that the statutory notice was served upon the present petitioner. Mr. Vakil next submitted that before filing of complaint under section 138 of the Negotiable Instruments Act in the court below, respondent number 1 has also registered an FIR for the offences punishable under sections 406, 420 and 506 clause 2 of Indian Penal Code against the present petitioner for the same set of allegations, and thereby accordingly to Mr. Vakil, the initiation of impugned complaint under section 138 of the Act is nothing but an abuse of the process of law. Mr. Vakil lastly submitted that as such the check in question has been obtained under correction. He further submitted that the complainant along with 2 police officers have come to the house of the present petitioner, and further threats and coercion the complainant was made to sign the check, to which later on the complainant has also registered the complaint before the concerned police station. By making above submissions, Mr. Vakil has prayed this court to quash and set aside the criminal case referred to above. Per contra, Ms. Moksha Thakkar, learned APP, has vehemently opposed the present petition, contending inter alia that the contentions raised by the present petitioner are in the nature of defense and can be made at the time of trial before the concerned magistrate. According to the learned APP, this court may not exercise its extraordinary jurisdiction under section 482 of the CRPC. Ms. Thakkar, learned APP, further submitted that it is not a case of non-issuance of statutory notice at all. Ms. Thakkar pointed out that the notice is sought to be served upon the present petitioner. However, name of the flat and area is correct, except the flat number. Ms. Thakkar further submitted that it would be a matter of evidence that whether in the given flat number is there any right, title or interest even prevailing or not.